Good morning. Good morning. The entire staff at the New Jersey Redevelopment Authority would like to welcome everyone to NJRA's webinar titled Zoning and Land Use Law in New Jersey. We would also like to thank our speakers for sharing their time, experiences, and expert knowledge in the area of zoning and land use law in New Jersey with everyone today. My name is Oscar Parham, and I have the honor to oversee NJRA's Training Institute. The NJRA Training Institute has been in existence for over 15 years. NJRA is a multi-million-dollar independent financing authority created by the state of New Jersey. NJRA functions as a comprehensive resource center focused on improving the quality of life by creating value in New Jersey's urban communities. NJRA invests financial and technical resources into redevelopment projects and plans that will create positive impact in our eligible communities. So if you have some time today, please go to our website, www.njra.us for additional information. Say that once more, www.njra.us for additional information. The NJRA Training Institute offers technical development services to our community leaders, real estate professionals, small businesses, municipalities, public, private, nonprofits, just to name a few. We offer our technical assistance via our in-person workshops, webinars like the one we're having today, municipal consultations, and our customized training. We also work collaboratively with our sister government agencies, NJDCA, NJEDA, and NJHMFA to serve our community redevelopment needs and its small businesses. Today's webinar will center around zoning as a major redevelopment tool to meet land use planning objectives and comprehensive revitalization. We will have presentations from our expert planner and attorney. So at this time, I'd like to give you just a brief overview of our expert speakers' extensive and very impressive bios. Our first speaker, Kristen Russell. Kristen Russell is a professional planner and project manager with Colliers Engineering and Design. Kristen has 20 years of experience in public, private, and nonprofit sectors. Kristen has written zoning code and redevelopment plans for towns throughout the state of New Jersey, with a particular focus on Hudson County and the downtown areas. Reflecting her appreciation for historic preservation, Kirsten authored the award-winning Gunther Mill Redevelopment Plan in Dover, New Jersey, which enabled the adaptive reuse of an old mill into a mixed-use center. In her leisure time, Kristen enjoys traveling the world, which we all would love to do, returning with global ideas to help improve our cities at home. Our second speaker today is Mr. Mark J. Cimarero. Mark J. Cimarero has been practicing law for nearly 30 years, and one of his primary practice areas has always been real estate law. In December 2021, Mr. Cimarero merged his 15-attorney law practice firm with Dakotas, Fitzpatrick, Cole & Gibbelin LLP, where he is an equity partner and a member of the real estate redevelopment, litigation, local government law, and employment law departments. The majority of his practice is real estate centered, focused on land use, redevelopment law, construction law, and related litigation, representing both private and public sector clients. His private sector clients include some of the state's largest real estate developers and real estate management companies. He also serves as municipal attorney and special counsel to dozens of public entities, including municipalities, counties, public authorities, and varying capacities, including, but not limited to, redevelopment law. Most relevant to NJRA are the facts that Mr. Cimarero currently serves as redevelopment counsel for the city of Clifton, Borough of Pompton Lakes, and Village of South Orange, and provides redevelopment counsel services for all related services for the boroughs of North Caldwell and Killingworth. In addition to his public sector redevelopment experience, Mr. Cimarero regularly represents private developers in redevelopment law and has seen through fruition many redevelopment projects throughout the state, including, but not limited to, the cities of Hackensack, Clifton, and the borough of Pompton Lakes. Please visit our speakers' company websites, which will have additional information at the conclusion of today's webinar, and also our NJRA registration page for additional information on our speakers' impressive bios. And I've only read just a very small amount. NJRA would like to thank our speakers once more, because we couldn't do this without you. We'd also like to thank you for attending today's impactful webinar.
Okay. Good morning, everyone. I'm Mark Cimarero, and as indicated, I think we're going a little bit out of order than originally anticipated. I am the attorney, and I will be discussing various rezoning methods and the procedures associated with them from a legal perspective. Primarily, there are two key ways to have properties rezoned. Obviously, rezoning becomes an option when you have a piece of property that is zoned in a way that is, at least to some degree, incompatible with what your proposed use is. Obviously, you always have available to you a use variance, but for various reasons, most of which deal with uncertainty and the expense associated with the gambles of going through an application and not knowing what the result is. If you're able to secure rezoning of the site through one of the methods we're going to discuss here today, that's a lot better for you. It gives you a lot more certainty on how to proceed and is the preferred course. So the two ways that primarily exist to seek rezoning to avoid the uncertainty of applying for a use variance are seeking a zone change through the passage of a zoning ordinance or redevelopment. The first method is what I'll discuss initially, and that's changing the zoning code by way of the passage of a ordinance amending the zoning code. The procedure to pass a zoning ordinance involves both the governing body, which generally is a council. It involves both the governing body as well as the planning board. The first step is that the governing body has a zoning ordinance that it seeks to introduce. That sometimes an ordinance may be suggested by the planning board. Oftentimes it is, but that ordinance does follow the two-step process plus an additional step, the two-step traditional process of all ordinances, meaning an introduction vote by the governing body, and then a public hearing that's hosted by the governing body with public participation at the time of adoption. However, a zoning ordinance involves the planning board in between. So regardless whether or not the idea came from the planning board or it came from the governing body, the zoning ordinance is introduced at the governing body level and it's voted upon. There's no public hearing at that point in time. It is then referred to the planning board for their review, which is known as a consistency hearing. Next. The consistency hearing involves the planning board evaluating the proposed ordinance and determining whether or not it is substantially consistent with the land use element portion of the master plan and substantially consistent with the housing plan element of the master plan. Our planner here will go into greater length and explain what the land use element and the housing plan elements are, but those are two key subcomponents of the master plan, which have a universal or a global planning perspective for the municipality in question. So as long as the ordinance is consistent with those components of the master plan, the planning board would be expected to recommend adoption of the ordinance. If it's not, they will recommend likely to deny the ordinance. And in fact, that's the duty that they're charged with. Next. At the time this goes back to the governing body, they hold a public hearing. That public hearing requires, by virtue of the municipal land use law, 10 days advance notice to all affected property owners. Those are going to be the property owners within the zone, in certain instances, property owners within 200 feet of the affected properties of the zone, and as well as adjoining municipalities that are within 200 feet of the zone change or zone alteration. At this public hearing, not only those individuals, but the public at large is given an opportunity to speak. And then after the public hearing, the governing body is going to vote as to whether or not to accept or reject the ordinance. If the planning board recommended the adoption of the ordinance, a simple majority of the governing body will pass it. If they recommended against it, there is still the possibility of the governing body accepting or adopting the ordinance, but they need a supermajority, a vote over the typical majority in order to adopt the ordinance and explain why with respect to the resolution associated with the same. When dealing with the passage of an ordinance, a zoning ordinance, you have to be concerned with what's known as spot zoning. And there's two key components, and this could get quite complicated, but to boil it down to its most simplistic terms, there are two categories of spot zoning: traditional spot zoning, or I actually don't have this on the slide, Venetra. Spot zoning or inverse spot zoning. Spot zoning is zoning that is geared to benefit a particular property or property owner and is inconsistent with the master plan or the surrounding uses of the property. And then inverse spot zoning is spot zoning that adversely affects a particular parcels of property in a negative or detrimental way that again is inconsistent with the surrounding uses. If the court, if challenged, and the burden of challenging an ordinance is on the person challenging it, so they would have to prove this inconsistency. If that is successful, they successfully prove that it is isolated, that it's to the benefit or the detriment of a particular piece of property, that it's inconsistent with the surrounding uses, that ordinance likely will be overturned and successfully invalidated. So that's always out there, and by and large, you'll find that if it's a single piece of property that's seeking to be rezoned, you're going to have a problem by virtue of the laws against spot zoning, and you may have to revert to either pursuing a use variance or the redevelopment option. So next. The redevelopment option is an option that could apply to an isolated piece of property. And this option is similar to a zoning ordinance. You need cooperation and interest from the governing body and the administration to pursue the change. And with respect to redevelopment, The municipality has to have a desire to encourage development and a willingness to work with individual developers. Nothing can be done to force this as an option. It's expensive because the municipalities will insist upon escrow agreements and in-term escrow agreements and developer agreements, which will pass their expenses onto the developer, which means that the redeveloper is ultimately going to be paying twice the legal fees, its own as well as the government's, twice the planning fees, not quite twice the engineering fees, because you're going to be doing more engineering on the private side than the public side, but you're still going to be paying their engineer to review things as well. So this option is expensive for the developer, redeveloper, and really is only viable if it's a more significant project. Next. As such, you can imagine that it's a much more entailed procedure. This procedure does start with the governing body. The procedure is highly regulated and set forth in Title 48 of the New Jersey statutes in the law entitled the Local Redevelopment and Housing Law. The first step is that the governing body needs to order that an investigation occur. That's done by way of passing a resolution requesting the planning board to perform what's known as an area in need investigation. The matter then is referred to the planning board, which will pass its own resolutions to hire a planner and instruct that planner to develop a map and perform an investigation as to whether or not the area in question satisfies the criteria necessary to qualify the property as an area in need of redevelopment. The planning board ultimately will have a public hearing relative to this determination, and ultimately, after public participation, issue a report to the governing body recommending whether or not the area should be considered as an area in need of redevelopment. Next. The governing body, if it so desires, would then adopt a resolution declaring the area in need of redevelopment. And then it has one of two options on how to proceed with having a redevelopment plan established. It could have its own redevelopment plan that it recommends to the planning board, in which case the planning board has 45 days to review and comment, or it could defer to the planning board and ask the planning board through its planner to establish a redevelopment plan for the property at that point in time. And that's generally the more followed course. As a matter of fact, I don't know that in any of my redevelopment projects have I ever had a redevelopment plan established by the governing body. It was always done by way of planner and planning board, at least with my experience. Once a plan is established and recommended, it gets referred back to the governing body, which must, if it's interested in doing so, adopt it by way of ordinance. And that again is a two meeting process, a vote to introduce it, and then a vote with a public hearing on adoption. Once adopted, that redevelopment plan will now constitute the new zoning that controls the properties within the area. Now, that could supersede completely all zoning that's in the area, or it could provide overlay options. It could do one or the other. And I've seen it in both ways. Next slide. There are 8 possible criteria upon which an area could be declared in need of redevelopment. The first one is that the generality of the buildings are substandard, unsafe, unsanitary, dilapidated, or obsolete. or are so lacking of light and space that they're unwholesome. That sounds pretty nasty. Number two is that they're discontinued buildings previously used for commercial, retail, not retail, shopping malls, office parks, manufacturing or industrial uses. Recently, the law, next, please. You'll see I highlighted on the next slide. Actually, it wasn't highlighted on that version. The first line, significant vacancies, was a recent amendment that was passed by the legislature in light of the online shopping assault on the retail industries, and then telecommuting and the assault that the office market has experienced as well. So now, if there are significant vacancies in these structures for 2 consecutive years, then that could be utilized as a basis for redevelopment. And I think that we have all now seen office buildings converted to residential or to mixed use. And we've seen regional shopping malls converted to mixed use. I know that I had a project in Pompton Lakes where we converted it and had storage facilities now intertwined and rezoned by way of redevelopment with shopping, as well as some residential components intermingled. So this has provided a lifeline to those property owners and to municipalities as well, because as you can imagine, these office buildings and malls would be white elephants, not generating anywhere near the tax revenue they previously generated, but for the fact that the rezoning has now brought them online and made them viable and vibrant and successful. And that's probably one of the most frequently used criteria, at least in the last 2 years, that I've come across. And it's by virtue of this amendment. Number 3 is that the municipality itself owns a piece of property that's been vacant for 10 years. And that is attributable to the fact of the property's location, remoteness, topography, something, its soil, something that's unique that makes it so undesirable that it's unlikely to be developed by private capital, but for the incentivization of redevelopment and tax abatements. Number 4, that the property essentially is blighted, that it's detrimental to the health, safety, and public. This is very similar to the first criteria. Number 5, the properties are simply underutilized and have remained underutilized because of divergent ownership. This is kind of common where you're dealing with smaller lots owned by a bunch of different individuals who aren't interested in working together towards a common repurposing of the area. This type of redevelopment criteria usually, at least in my experience, has been relied upon when using a condemnation model for redevelopment. And that is, I guess, a little side note, right? There are 2 ways or 2 methods or options with respect to redevelopment. We could go with condemnation or non-condemnation. Condemnation gives the municipality the ability to get them property and take it out of the hands of private owners and place it in the hands of redevelopers to redevelop in accordance with the redevelopment plan. Non-condemnation is successful as well. It tends to be the redevelopment of choice in suburban New Jersey, and typically the rezoning that occurs through redevelopment is so financially favorable. It makes the property so much worth so much more money that the property owners finally decide to either develop it themselves or sell it to a developer that's willing to pay them a lot more money than their property was previously worth. In the urban centers, condemnation is used a lot more frequently. Next. The next criteria is 5 acres or more where the building has been destroyed by fire or natural catastrophe and significantly depreciated as a result. Number 7 is that the property is located in an urban enterprise zone. And number 8, which is really very rarely used, I guess it's often cited, but not isolated, not on its own. And that's that the property is located within a smart growth planning district. Next, the benefit of going a redevelopment route is that you have the option of long-term tax abatements. The long-term tax abatements are available in areas in need of redevelopment. It's known commonly as a pilot payment in lieu of taxes. It could be up to a term of 30 years. They must expire within 35 years of granting them, which gives you 5 years to construct the project and get it up and running. If it takes you longer than that, then you're shortening the length of the tax abatement period. The minimum service charge, which is how it's referred to in the statute, that your minimum payment in lieu of taxes, is going to be the last taxable year, the last year's taxes prior to the implementation of the pilot. So it can never go before that. The land is still traditionally taxed and is apportioned as it was previously among the Board of Ed, county, and municipality. Next. There are 2 formulas that the pilot can be conditioned upon. One is the cost of the project, and the cost basis formula makes the pilot at least 2% of the total project costs. And the other is a revenue basis, which means that the pilot cannot be less than 10%. Now, the long-term tax exemption law is complicated. This is really boiling it down to some very simplistic terms. In order to qualify, you must create an urban renewal entity. It must be a single purpose entity. This must be its only use. It is a limited dividend entity, meaning it cannot make more profit than, I think it's 12%. And if it does make more profit than legally permissible, the excess revenue has to go to the municipality. And there's an annual audit basis upon which the urban renewal entity has to open its books essentially through to an auditor and provide a report showing all of its revenue, all of its expenses, to confirm both what its income is, so that the gross revenue basis can be calculated, and to show that it's not exceeding the profit maximization or the ceiling. Next slide. There is one alternative that's a little bit smaller and a little bit streamlined than redevelopment, and that's an area in need of rehabilitation. These 2 options do parallel each other significantly. Rehabilitation is more streamlined, but it still does involve action from both the governing body and the planning board. It does have for it, however, some different criteria. And those criteria are, the first one, that a significant portion of the structures in the area are deteriorated or substandard. The other is that the housing stock is, more than half of the housing stock is over 50 years or older. Next slide. There's a pattern of vacancy, abandonment, underutilization of the property in the area. Or there's a persistent arrearages and property taxes in the properties in the area, or there's an environmental contamination that's hindering investment in the area, or the infrastructure in the area is over 50 years old. An area in need of rehabilitation also has available to it short-term tax abatement. It does not have to be an urban renewal entity. And the formula for the short-term tax abatement is a formula that works off of traditional taxes. Each of the 5 years are a percentage of what the taxes would be if the property was traditionally taxed from day one. And it goes 20, 40, 60, 80, and then ultimately 100% of what the traditional taxes are. The tax abatement with respect to a long-term tax exemption is formula based upon, as I had indicated before, income or cost of construction, but towards the middle and upper half of the term, there are alternative minimums that have as benchmarks what the traditional taxes are. And they again work off of the same concept, 20, 40, 60, 80, and 100. Starting at year 16 in 5-year increments, you either use the income-based formula or 20% of what the traditional taxes would be, whichever is higher, or 40% of traditional taxes, which is ever is higher, and then again 60, 80 in the 30th year, and then once the exemption period's over, you're at 100% traditional taxes. So those are really the two options that you have available to you, and the benefits and I guess pitfalls and concerns that are attached to proceeding with either of those two rezoning options if you want to avoid pursuing a use variance and the uncertainty associated with it. And that's my presentation.
Hello, everybody. My name is Kristen Russell, and I'm the planner for today's presentation. Thank you, Mark, for that first half of the class today. As you all heard, Mark covered largely the approach of redevelopment. And while I will touch on that, by and large, my presentation is going to cover rezoning. So there are three approaches to zoning, three approaches to solving the problem. One is zoning, then we have rehabilitation and redevelopment. You'll see I have a table here describing the different problems that can be solved by each. These range from the desire to use eminent domain to pilots, land use control, designating a developer. So from this chart, you can clearly see that there are more opportunities for some of these problem-solving issues in rehabilitation and redevelopment, but that doesn't mean that zoning is without its own benefits. Many times, you just need to have permitted use in place, and the project can go from there. It's not always that complicated. I do have one slide here going over redevelopment and rehabilitation. I don't want to spend too much time on it since Mark did this already, but I'll just reiterate that redevelopment and rehabilitation is subject to the local redevelopment and housing law. There is a process where the governing body and planning board are both involved in the redevelopment study, or the area in need study, excuse me. And then if that is found to apply, and if that is adopted, then a redevelopment plan will be written, generally by the planning board, and when recommended and adopted by the governing body. There are hurdles to overcome when you're working with redevelopment. The area must qualify as an area in need. And that is not always possible depending on the condition of the site. You do, however, have the ability to designate a developer. There's the potential for more givebacks from a developer. You have eminent domain at your disposal, at least in terms of redevelopment. Tax abatements, there's the opportunity for design criteria that may not exist in your zoning code that varies from one town to the other. And bear in mind, though, that redevelopment plans do not give any authority to the Zoning Board of Adjustment. So once those standards are put in place in a redevelopment plan, you may be able to grant a developer C variances, but no D variances. So they need to know, or I should say you as a municipality, need to know exactly what you're willing to accept on that site. Or if you're a developer, you need to make that clear to the municipality ahead of time before that plan is adopted. The only way to change or to get a different use or a D-variance classified height, so forth, is to amend that plan. And you really don't want to be doing that. So you really need to know ahead of time when that plan is adopted, what you expect that site to be developed as. And the plans can supersede or act as an overlay to the existing zoning. But I'm going to spend the majority of my time today talking about zoning in the more traditional sense. And that zoning, as most of you probably know, is subject to the municipal land use law. When you want to amend the zoning, the planning board will make a recommendation to the governing body for their approval. It does require public notice or a master plan reexamination. And this is because your zoning needs to be consistent with your master plan. Your master plan has a land use element, and in that, it's going to talk about the existing conditions of your municipality and what the municipality sees as being their vision going forward. So if you're a developer, you need to look at that master plan vision. And if you're the municipality, you need to keep that in your mind, because when you are going to rezone a site, if it is inconsistent with the vision of the master plan, that master plan needs to be re-examined. The highlights of zoning are that it's straightforward. There's no need to meet the area in need criteria. So if your site is actually in good condition and it really just for whatever reason hasn't generated interest, this may be a better option. And the standards will be absorbed into the zoning code. You're not going to have an extra document that people need to refer to when they're developing this site or looking at the standards for this site. Also, when something is rezoned, the zoning board of adjustment may review applications for that site. So if a D-variance is triggered by whatever ends up being proposed for that site, it does have the ability to go to the zoning board of adjustment. Of course, it can still go to the planning board. So just in general, I have written here some effective zoning concepts. These are ideas that often are beneficial and effective in revitalizing specifically downtown areas. You may not have a downtown area, so keep that in mind that some of these, they don't universally apply, but depending on the scope of your site, these are often useful concepts. That's mixed use, the importance of sidewalks, and the importance of design. Depending on the municipality, some have robust design standards and some have almost none. But the idea of hidden parking, big windows, the scale of street width to building height is very important. And materials, if you want to reinvigorate, redevelop an area, you want to make sure that slipshod buildings aren't going up. And so there is the ability to regulate, you want masonry, you want, different quality materials rather than some things that the town may have found to be problematic or not up to their standards. And then there's the notion of a third space. This is really, when we look at how people live their lives, they have their home life, they have their work life, and then there's the third space. And that's kind of where people tend to congregate, where a community may hold its events, where people may just linger. Sometimes it's a cafe, sometimes it's a plaza. It can really, really vary from one town to the next. If there's a riverfront in town, that might be a great third space. But if you can create that third space or create something that links to an existing third space, you're pretty much going to be on a good track. I'm going to go into detail about a handful of effective zoning concepts that are a little bit more complicated, but have shown to be effective where they have been put in place. The first that I'm going to talk about now is bonuses. This is where a zoning code may give height, density, parking, coverage, you name it, type of bonus to what is the baseline existing in the code. So they're often done in exchange for amenities or public benefits. So here's an example that I'm showing you from Jersey City. The site, the bottom photo, you can see, if you can see my arrow, it's this big square building. That site was developed with the residential density bonus, where the developer was given an additional 70 units per acre when an open space beyond that which was already required was provided. And it had to be a public park, deed restricted for a public park. And the top picture on the right that you can see here is the park that was dedicated in exchange for this higher density. And you can see the people having a lot of fun, and it's a well-used park. So Jersey City had decided that it was a reasonable exchange to allow a higher intensity of development if this public park was going to be created, deeded for public use in perpetuity, and all that was going to be done at the developer's expense. Another zoning concept is the transfer of development rights. We don't see this too often, but it is available. It's a technique often used in more rural towns, where you can permanently preserve rural or open space, farmland, etc., which we classify as a sending zone. And the density that would be was previously zoned for those sites can be transferred to a receiving zone. So say you have a farm that is 100 acres. If the zoning was 1 unit per acre, you've got 100 units available if that farm were to be taken out of service and subdivided. But maybe the municipality really wants to encourage the preservation of farmland. So what they can put in place is the ability to sell the value or sell those 100 units into a more concentrated area that they've defined, and allow that more concentrated area to receive these extra 100 units on top of what was already permitted there. An example here is Chesterfield, New Jersey, where they had over 7,000 acres of farmland in the agricultural zone. And they had a traditional neighborhood zone elsewhere in town. The map here is a little bit hard to read, I know, but the green areas are the sending zones that are permanently preserved. And this area towards the top in kind of the light pink, it says receiving zone. All of the density that would have normally been allowed in the farmland zone is moved to that receiving zone. And this is complicated because there's an exchange of money, right? That farmer is going to want to be compensated for the inability to eventually cash out on his land. Sometimes that's done through a private transaction. A developer can go to a farmer or a property owner of this agricultural or undeveloped land. It doesn't necessarily have to be agricultural, and offer to buy it. Another way that it works, though, is that a municipality may create a bank, and they may buy the land in the sending zone from that property owner, bank it, and then at some point in the future, somebody can buy that, the value of that. In that second example, there's the need for a municipality to have some money, which is not always the case. But in the first example, where the developer and the property owner are directly engaging with each other, it does not require the municipal expense. It's a little bit more complicated than what I just told you, because some towns will look at the soil and say, oh, well, actually the better the soil, the more valuable. And so maybe it's not a 1-to-1 ratio. maybe certain acres with very valuable soil might be worth more than 1 unit per acre. Some towns do it that way, where that takes extensive study as to the value of any parcel or any portion of a parcel. But generally, I think I'm just trying to get across the idea that you can move density from a preserved zone to a more concentrated town center zone in order to encourage development in that downtown. Another effective zoning concept is the planned urban development. I have an example of this later in my presentation, but the MLUL goes through the requirements of a planned urban development, and this is going to be, it has to be a minimum of 10 acres developed by a single entity, and it needs to be mixed use. There needs to be residential clusters, there needs to be commercial, and it's really creating a bit of a new community, including all of the streets, all of the infrastructure. And much like redevelopment, this does give the flexibility to negotiate with developers, which is more limited when you're working with traditional zoning. Some towns will use planned urban development to satisfy their affordable housing requirements. It allows the requirement for open space and amenities. It also allows the ability to shift density within a site. So you can cluster the homes in, say, the northwest corner and have parks in the southeast corner, or however you want to design that site in partnership with the developer. Another thing to consider as a benefit of PUD is that the developers generally pay all of the project cost on these, and they are going to be providing streets and the infrastructure that is often quite expensive for a municipality to pay on their own. Now I have a few examples that I just want to go through that touch on the approaches that I mentioned already. The first is Robbinsville Town Center. That was done with just a rezoning to a town center rezoning. You can see in this aerial photograph on the right, there's kind of a radial pattern to their development. The heart or the bullseye of that radius is, and across the street here especially, there's some retail components. And then as you extend beyond there, some residential components. It's 140 acres, so they had a very large site. The downfalls of this was that it took them 25 years to get here. So patience is a virtue sometimes, especially when you've got a really large site that is going to be done in phases. The benefits are they've got a mixed use development. There's open space incorporated into this project, a great street and pathway walking network, and they used density transfer. They had a rural residential zone, and they were able to shift some of the density that was previously attributed or permitted in those zones and shift it to this town center. The takeaway is that they've created a robust zoning code for mixed use, but it required patience. And we've got Clark Commons. This is a former industrial site that was simply rezoned to allow commercial shopping. The downfalls are that this is a pretty standard shopping center, strip mall type of site. But on the flip side, they eliminated heavy industry and they got some ratables. So depending on what you're looking for, if you're just trying to rezone to get rid of an undesirable and disused site, this might cut it for you. The standards for use clearly worked. And the downfall, as I mentioned, is that the bulk standards resulted in a strip mall that may serve the shopping needs of the community, but didn't create any sense of space. Now here's an interesting one. This is the Jersey City Pedestrian Plaza, and this was created without even touching the zoning. So think about the site or the place that you're looking to redevelop, and ask yourself, what could really be done outside of zoning? This street, 10-ish years ago, was a typical downtown street with 2 lanes of traffic, and I forget if it had 1 or 2 lanes of parallel parking. But it was a traditional street dominated by cars. And the Jersey City decided to do a demonstration project where they closed it to vehicle traffic. There was a lot of business resistance. And lo and behold, within, I think they did it over the course of a summer. And by the end of that summer, businesses were praising it. Other neighborhoods were asking why they couldn't have one as well. And over the course, so then they decided to make it permanent. And then over the course of the next, I want to say 6 to 10 years, improvements have been made permanent. So what you see actually in this picture is during, it's not how it looks right now. Right now, that street has been paved over with permanent pedestrian pavers. Some streets furniture has been added beyond what you see in this picture, and it has been extended several more blocks. So if the municipality that you're looking to, that you either work for or looking to develop in, has the political will to resist some initial pressure not to do this, and if they have a long-term vision to make some capital investments, sometimes you can just change a place around through public investment. If you have a great place already and just takes some money and creativity, you might not even need to touch your zoning code. And then we have North Market in Montvale. This, the top picture shows when it was a Mercedes-Benz headquarters. This is the bottom half of the site, shows extensive parking lots and several office buildings. The top part of that site now is DePiro Farms, which is also the top part of the second photo. And then they went to North Market, which is the bottom half of this middle photo. You'll see 2 main buildings and then some secondary buildings. There are a total of 6 buildings. They have a total of 350 apartments, over 40,000 square feet of office space, 150-room hotel, 94 square feet of retail, a corporate office headquarters, public plazas, affordable housing. And this was all done through rezoning from OR4 to a PUD. Remember, we talked about a PUD earlier in this discussion. It's where a large site can be zoned for mixed use development, has to include residential, has to include commercial, has to include open space. And that's done in coordination between the town and the developer. And in this case, it was really quite successful. You can see the bottom photo shows the final results. The downfall of a PUD sometimes is that unless you're creating a PUD in an already central location, it tends to be an isolated site, which means getting there, being there might be a really interactive and fun and vibrant place, but getting to and from that PUD still requires a car. So you're not going to get too much, you're still going to have a really high parking ratio in most of these cases. The site that was developed here at North Market has pretty much the same parking ratio requirements that exist elsewhere in town. So that's a drawback, that you need to have that provision. You need to account for that parking provision. But the benefits of this site are that it's truly mixed use. They have a 15% affordable housing provision, and they got a whole lot of ratables on a site that was a vacated Mercedes-Benz office building, and they have a great sense of place. And that is my final example and my final slide. But I am happy to take questions about any of these concepts that I've given to you as part of this presentation.
Okay, we do have some questions. So the first question I see is, was JC's Plaza financed through CAP improvement or private funds or other?
As far as I know, it was capital improvements.
Okay. Another question is there a difference between the two terms planned unit development and planned urban development?
I'm not familiar with planned urban development, but let me check the handy municipal land use law.
Okay.
Yeah, I mean, planned urban development is not defined in the municipal land use law, so I'm not familiar with it. If there's an example that that somebody wants to give, I can try to dissect that, but a planned unit development can happen in an urban location or otherwise. So I'm not quite sure how to answer that question, other than planned urban development is not a defined term in New Jersey.
Okay. And also, someone asked for details that relate to traditional and inverse spot zoning.
Mark, you want to take that one?
Okay, let's see.
Would you like me to repeat the question?
Yeah, please. And
Okay.
I tried to put on my video, but I couldn't put the video on.
Okay. It asks for details that relate to traditional and inverse spot zoning.
Okay.
And it says, can you provide a brief explanation to support the discussion around spot zoning to forward? I'm sorry, 1 second, I didn't proofread this. Okay, we're gonna move on to the next question.
Well, I could answer. You want me to answer that one? I just
yeah, if you can.
Yeah, sure. Okay, so a simple example of spot zoning would be you have a development, say you have a 10-block development of nothing but single family center hall colonial houses, and someone in the middle of one of the blocks in the middle of this area all of a sudden wants to put in a 4-family house, and they pass an ordinance to permit that property, or even 2 of the properties would be considered spot zoning under those circumstances, for multifamily houses. It's inconsistent with the surrounding uses. It's benefiting the property owner. You could apply that type of fact pattern to virtually any type of scenario, any type of competing uses, or densities for that fact. You could also have it apply to height. If there are height limits and you're going to make an exception and it's completely inconsistent with what's around it, and it's restricted geographically to this a parcel of property that is surrounded by different height, lower height, it could apply there. Inverse would be a sample, and the case that's on point is this case out of Weymouth Township, where there were retail or office. I think it was retail, but it may have been offices all around. The area was zoned for whatever that commercial use is. And there's a piece of property in the middle, and they were going to construct another consistent, high-density commercial use, completely consistent with everything around it. So if there were office buildings around it, they were going to put up another office building. If it was retail centers, they were going to put up another retail center. And there was public opposition to it, saying, look, we don't need this. This is going to be creating a whole bunch of traffic. And, they went so far as to justify it, saying, our master plan says we should be developing things that do not intensify traffic, and some other goals of the master plan were arguably satisfied by this. But it created an isolated detriment to this one piece of property that was inconsistent with the restrictions that applied to the properties around it. And that was found by the court to be inverse spot zoning. So those are two examples of spot zoning, one inverse, one not. One beneficial, that's spot zoning; one detrimental, that's inverse.
Okay. Someone also asked, is there a way to rezone wetlands?
Well, you always could rezone by way of a zoning ordinance. I don't know. I guess the real question is, what's your goal? Why would you be trying to rezone wetlands? Because there's obviously some significant limitations associated with that.
I mean, wetlands can be zoned anything.
Yeah.
That doesn't change the fact that you have environmental constraints.
Right.
So a
The DP
wetland
regs.
could be zoned park and open space. It could be zoned your highest intensity commercial use. That doesn't mean that you're going to be able to actually build anything on the site because you have environmental constraints.
Exactly. So what I mean, if that person could say what the goal was, that may be a larger question.
Okay, I'll look out for the
Okay.
response. Someone asked, how does unsized lots play into, I'm guessing, zoning and planning?
Unsized?
Yes.
I don't understand. Do you know what that means, Kristen?
No, I bet they meant undersized.
Undersized?
Yeah.
Well,
So,
so there is the doctrine of merger that does apply to undersized lots, which if you have an undersized lot and it's under common ownership with an adjoining lot, by the doctrine of merger, it should merge with that lot. That's a property principle that's out there. To develop an undersized lot has built into it already some variances associated with it. From a zoning perspective, I guess the one thing that comes to mind is if you rezone whatever that bulk criteria that is lacking or deficient and make it an acceptable condition, you now have made it no longer an undersized lot. You made it a conforming lot. So you could, if it's practical and people within the municipality are amenable, if you are able to make that a conforming lot, you could, through zoning, make it a developable lot now, potentially.
the flip side of that, though, is that you could be creating a non-conforming lot by rezoning.
True.
You could, if you have a 5,000 square foot lot and you want to rezone the site for a 10,000 square foot minimum lot area, now you've created a situation. On the one hand, you may encourage property owners to work together or buy each other out to consolidate their lots. On the other hand, you may be forcing everybody involved into a situation where they have to ask for a ton of variances in order to develop their site. You can't render the site useless.
Mhm.
They still need to be able to do something with that parcel. So,
And you're
um,
creating a ton of non-conforming, pre-existing non-conforming uses.
or even if the site's vacant, it's not
Yeah,
necessarily used,
yeah,
but just like a lot that is going to be difficult to develop with, and is you're going to be basically backing yourself into a corner of needing to grant variances.
right.
Oh, okay. Some said 6 acres are for sale near them. You can build on a portion of it. The engineers say no, but land use lawyers say you can turn it into farmland and then over time subdivide it and build on it. This is pertaining to the wetlands question.
You know, well, your option really is rezoning. Uh, this is property that's not owned by the town, correct? Um,
That
and
is unclear.
Yes, somebody just said correct.
yeah, okay,
Oh, correct.
all
Yes.
right, yeah. So I don't see that falling within any of the redevelopment criteria. Um, so I think your only option is rezoning. So if the municipality is interested in rezoning, uh, then I guess that's a possibility if the attorney is aware of the fact that you could get relief from whatever the wetland regulations are. Maybe the wetlands aren't comprehensive. Maybe it's only covering a portion. Maybe they're spotty. Maybe they're intermediate, non-priority and intermediate, interdispersed throughout the acreage. Maybe that's possible. I don't know. I
Okay. And
think,
it also says it's owned by someone out of the state.
okay. Well, I would definitely talk to an attorney that is not only familiar with land use, but with wetlands regulations. And I think that if you're considering it, I would be bringing in an environmental engineer real quick as well to make sure that this is something that makes sense. The one thing that I'm always cautious of, and I think Kristen will agree, our environmental regulations in this state are really escalating rapidly. And just because you're able to do something potentially today doesn't mean you're going to be able to do it 5 years from now. So if this is not something that you are going to be in a position to make a play on within the next, 18 months, 24 months, I don't know that I would give you the advice. I think I advise against buying wetlands with the intent that you're going to somehow convert it 5 years from now, because whatever the wetlands regulations are today, I would bet my house that they're going to be more stringent 5 or 10 years from now. Governor Murphy just recently signed an emergency bill that increased stormwater management regulations and requirements almost twofold on an emergency basis, where ordinarily it's a 1-year process. And it kind of evolved out of a tragic situation that happened in Jersey City that some of us may have heard about, where a child had drowned in some stormwater culvert or something like that. And this was a legislative reaction. Usually it takes about a year for the regulations to be considered because they're onerous, and they had just recently been changed. And now I'm sure they're going to be challenged in court, and I don't think that they're going to really survive a challenge in court, because I don't know how the state proves that this was a state of emergency. It's tragic, I agree. But I don't think it was a state of emergency, and I think it's very detrimental to real estate development. Notwithstanding that, it shows the composure of the state with regard to environmental conditions, and I'd be very, very hesitant to be rolling the dice. Make sure you're crossing your T's and dotting your I's.
Okay. Um, this next one says, is there a standard across the state on how many units per acre a town typically builds? And is there a comparison of what a city would build versus a more suburban town, Jersey City versus Milburn?
So there's definitely no standard. I mean, you're going to see places where the zoning is multiple acres per home. And I can tell you in Jersey City, the minimum lot size is 2,500 square feet. I forget off the top of my head what that is per acre, but it's going to be different than any place that's suburban, much less rural. And so you really need, and I'll also caution you to not let density scare you. What I mean by that is there are some very cozy and I'll say quaint suburban development that do not feel as dense as the numbers work themselves out to be. That may be through the use of clustering and shared open space, or just housing topologies that mimic a single family home that may have more than one unit within them. So it's not just the number that you need to think about. Also, a number of the density number is not as predictive of the number of people as you may initially think. And what I mean by that is that a single family home may have one person or 7 people, depending on the family structure. Or actually, let me give you a better example. An apartment building might have 10 units in it, but each of those units may have a different number of bedrooms. And so there may be 10 people living in that apartment building, or there may be 40 people living in that apartment building, but the density is the same. The density of units per acre is the same. So just density is a little bit tricky in understanding how it looks in reality, but there is definitely not a standard density across the state.
Okay, someone said, can you explain the difference between a C variance and a D variance?
Sure.
You want me to do that, or you want to do that?
Either one, and I guess the other will chime in, however you want to do it.
Okay. A C variance is a standard bulk variance. So this is these are both found in the municipal land use law, and the name C and D comes from the subsection of the code that it's found in. So section C deals with things like setback, front yard setback, lot width, lot area, parking, and all of these are found in the zoning section of a municipal code. And they are all, there are legal requirements for the proofs that you need to give in order for the planning board or zoning board to consider and grant these variances. Section D is the next section of the code, and this deals with use, height, when the height is greater than 10 feet or 10%. So if it's less than that, it's still a C variance. Density.
Floor area.
Thank you. Floor area and conditional use. These 5 variances have a much higher bar that the applicant needs to prove in order to be granted these variances, the highest of which being a use variance. And these are things like showing that it's not going to, be detrimental to the zone plan and so on and so forth. And that's getting into some legal issues, but there are two separate sections of the municipal land use law. The C variances are more minor, let's say, and the D variances are the major variances. And oh, by the way, only a zoning board can hear the D variances.
Okay. The next question says, can you split a confirming lot consisting of a one-family dwelling and a mixed-use building into 2 lots?
It would depend on the,
Enough
if you
information.
have a lot with 2 structures on it, it would depend on the lot area and bulk and lot requirements of that zone as to whether or not it can be subdivided. And if it were to meet those requirements and the setbacks according to where that new lot line is placed, most likely you can subdivide it. If there were variances triggered by that subdivision, you would need to ask for those variances.
I agree with all that, and I would go one step further and say that likely that property already is non-conforming or already has a variance because you have 2 separate uses and 2 separate principal structures on the site. So I don't think that it would be a terribly heavy lift unless there's something particularly onerous about it because it's already non-conforming.
Yeah, and the
Okay.
only one thing to consider though, there's always like an exception to a question like this, and we not knowing the layout of that
Right.
lot, like if one building is behind the other building, then you have
Yeah.
access issues, and do you need to have an access easement, and is it a flag lot type of thing? So we can't give
Yeah, they
an
both-
exact
yeah.
answer, but
Okay, she
you
says,
sort of can.
or I'm sorry, they said area is 0.89 located in South River, New Jersey. The single-family home lot will be non-conforming.
That's still, I mean, I think that what Kristen said was right. If both uses have frontage and access to a major roadway, I would think that that's key to success. If not, if this subdivision is going to result in one of these properties being landlocked, the answer is going to be no. I don't think it would be worth it. Depending on what your goal is, you may consider condominiumizing the property, and you could separately deed it without subdivision under those circumstances.
Okay. Uh, Next question. Have you heard of leasing wetlands to the state/government for 15 years, or is that only farmland and wetland?
I
I've never
haven't.
heard of it.
Okay. Next question. Is it typical for developers to submit denser plans than a redevelopment plans allow? And
No,
if
they
so,
can't. They can't.
okay.
They may
Okay.
request an amendment to the plan, but
Okay.
you can't get that variance.
Yes.
Density,
says-
it qualifies as a D variance, which I just explained, and redevelopment plans are not eligible for D variances.
Okay, I think you guys just answered this next part, but I'm just going to read the whole thing. And if so, is it common for towns to amend a fairly new development plan, one written within the last 5 years, to fit the developer's building, even if the developer's plan is double the size of the redevelopment plan? It says the planning board has to review to ensure consistent with master plan and unsure how to redevelop the plan can be amended by doubling, its density and still be consistent with master plan.
I mean, that's very specific to a town.
Okay.
Opening a redevelopment plan for amendment isn't necessarily uncommon, but whether or not a town is amenable to double the density is a very local and very personal preference. And I would say that a town should not let a developer bully them, but they should be aware of their own vision and their own reality. Can it happen? Should it happen? Sometimes, yeah. Sometimes it shouldn't.
You know, to just add to that, you may have a situation where you've had a redevelopment plan that was lying stagnant because there wasn't enough density to incentivize the development. And after time, they learn that, and the developer says, well, look, if you give me this density, I'll get the project moving. In Hackensack, they ended up having a 161-acre rehabilitation zone, and they custom tailored a whole bunch of different redevelopment projects within the rehabilitation area. And in order to incentivize development, they, in the rehabilitation zone, identified criteria for what they classified as catalyst projects. And as long as you had an acreage of a certain size that entitled you to a certain size footprint building, they would allow you to go higher and get greater density on that site. And they recognize the fact that when you're talking about a broader redevelopment, rehabilitation concept, that in order to get the ball rolling, you have to do something to get the first project going, because then it starts to propagate on its own. So Hackensack has been very pro-development, not in a reckless way, in a very cautious and careful and thoughtful way. But they have modified that from time to time in order to get their redevelopment and their city repurposed. And they've done a great job at it. So it was very common for them to redo things, at least at the beginning.
Okay. This one says, Kristen mentioned a rezoning redevelopment method that would eliminate the ability to apply for D variance. What exactly prompts what exactly prompts the ability to no longer have D variance applications? Sorry if I heard wrong.
It's not rezoning. Redevelopment precludes a D variance. So if you're going to go through the redevelopment process and adopt a redevelopment plan, D variances are no longer eligible. The only method to effectively get a change in density or use or whatever is through amending the plan. Through traditional zoning in your municipal code, you can get a D variance.
Okay.
Well, I'm not going to say you can get one. You can ask for one.
Okay. Someone asked, can you subdivide a residential lot into two if a home currently exists?
Yes.
Yeah. That's not enough information, but yeah.
Okay. If a development project is being challenged from a planning board decision versus zoning board decision, typically, would it be best for a developer to revise their plan or move on? And what advice would you give a municipality?
You know, it's I do a ton of that litigation. I do so much of that litigation that some towns hire me just to defend them when they get sued on that type of litigation. And it's both zoning board and planning board prerogative writ. And that wouldn't be the criteria upon which I would base that decision. It would have to be based upon what was done at the hearing and the basis of the challenge. With that being said, if you are challenging a D variance, the granting of a D variance, your chances of success in doing that, just because of the standard that the applicant had to be held to, your chance of success is greater in overturning it than a planning board decision by virtue of what that standard is. And there are certain presumptions against granting these variances. But there are standards that have to be followed. And if those standards are followed and the evidence and the burden of proof is satisfied at the hearing, you're not going to prevail in challenging them. And I have routinely, prevailed in both defending zoning board of adjustment decisions as well as planning board. So that in and of itself would not be the basis of the decision or advice.
Okay. The next question, can a pilot go longer than 30 years if there are multiple contiguous sub-districts zoned for redevelopment?
Well, the short answer to that question is no, but I think that the question could be rephrased. You don't have one pilot for the entire redevelopment zone. So, for example, in Clifton right now, the On3 project, which was the former Hoffman LaRoche site, is I think it's like a 90-acre campus. And there's a separate pilot for each building. So as the building comes up, there was a separate pilot for each building. In fact, there was a medical school that was constructed. Initially, it was supposed to be a partnership between Seton Hall and Hackensack Medical Center. Now it's just Hackensack Medical Center's medical school. And that building was subjected to 2 different pilots because the construction for the different portions of the building that were subject of the redevelopment commenced at different times. So from the beginning of the pilot to the end of the pilot, it can't extend more than 30 years. But it doesn't have to start at the same time, even in the same building. So if it's staggered and it's a separate pilot, theoretically it could go longer.
Okay. The last question I see here is, can the public speak at a planning board meeting that is reviewing amendments to a redevelopment plan since it's a D variance?
There are no,
Yeah.
amendments to redevelopment plans are not D variances. So taking that part of the question out, when the planning board hears amendments to a redevelopment plan, the public is generally offered an opportunity to speak. However, keep in mind that it's the governing body that is going to adopt it. And so that's actually, I don't want to say the better place to speak, but they're the ones who are making the decisions. So they're the ones you want to influence. The planning board will give a recommendation. So most towns will want to hear what the public has to say, but the governing body might even be a better place to speak.
Right. At the hearing for adoption, it will, because that has to be done by way of ordinance. And at the public hearing upon that has to precede the vote to adopt, the public's given an opportunity to speak.
Okay. And
those are the people that you vote for, by the way. So.
Right. Okay, so that was the last question. I am going to close that out, and I am going to thank you all for speaking today. It was a very informational webinar, a lot of takeaways. And before I let Craig come on and do our closing remarks, do you all have anything else that you would like to add?
I'd just like to thank you for the opportunity to speak. I think very highly of this organization. I think you folks have done a great job putting this program on, and I'm very happy to be able to share any information I can to help people.
Yeah, thank you, everybody. Good questions.
Good morning, everyone. Thank you. My name is Craig Sawyer, and I'm the lead trainer for New Jersey Redevelopment Authority. And I'd like to say thank you very much, Mark Serrano and Kristen Russell, for your thorough presentation on zoning and land use, and for spending the time to answer the various questions that we have had regarding how to effectively and creatively use zoning in New Jersey. We also like to say thank you for all the participants who joined us today. And we also welcome you to participate in our next month's webinar on comprehensive real estate development, learning the real estate development process, which will be held on July 28th. So again, thank you, everyone. And I hope this was enlightening discussion. Again, thank you, Mark and Kristen, for your time. Thank
Very
you.
welcome. Thank you.